Our first panel is on international taxation, and I'll do this in alphabetical order by last name. Stuart Kasner, first of all, he was my student. And, well, I don't want to get too sentimental, but today, every presenter in all three panels were my law students. And all of them went on to get their LLMs in taxation, and I know all of them are extremely well respected in the South Florida and national community for their expertise, and I hope that their practice is making them very happy. Stuart is a partner at Holland & Knight's Private Wealth Service Group. Stuart advises foreign and domestic clients on U.S. federal income tax and gift and estate tax matters associated with their cross-border investments, including U.S. real estate investments and business activities, as well as U.S. pre-immigration planning. His practice also includes forming overseas complex international corporate trust structures and implementing international reorganizations. Mr. Kasner is board certified in tax law by the Florida Bar and is recognized as a leading attorney in his practice by the Legal 500 Best Lawyers in America and Chambers High Net Worth Guide. Stuart Kasner. Jennifer Winosek. Jennifer also is one of my former students, and she's a partner in the law firm of Bilzen Sundberg. She's recognized as a leading tax and a trusts and estates lawyer in the Chambers High Net Worth Guide, City Wealth, Florida Super Lawyers, and South Florida Legal Guide, and previously recognized by the Florida Daily Business Review as one of their 40 under 40 rising stars. Jennifer has general international tax planning experience and has significant experience with domestic and international trusts and estate planning matters for high net worth individuals, multi-jurisdictional estate administration matters, acquisition, maintenance of sale of U.S. estates by foreigners, pre-immigration planning, expatriation planning, international reporting and compliance, offshore voluntary compliance, and representation of family office. Jennifer Winosek. Lauren Klein. Lauren Klein is also one of my students and got her LLM in tax from the University of Florida. Lauren Klein is a private wealth services attorney in the Miami office of Holland & Knight, where she focuses her practice primarily in the areas of international and domestic taxation for high net worth individuals, trusts and estates, and closely held family structures. Ms. Klein advises foreign and domestic clients on U.S. income tax, gift tax matters, including cross-border transactions. Ms. Klein has significant experience forming and overseeing complex international trusts and corporate structures. She also routinely counsels clients with respect to pre-immigration planning and tax treaties. In addition, Ms. Klein is well-versed in advising on domestic and offshore tax reporting and compliance, including the Foreign Account Tax Compliance Act, FACTA, and the Common Reporting Standards. Lauren Klein. So without further ado, I'm going to allow the panel to take the floor.
Okay, I'm very happy to be here, and just, you know, in advance of really speaking, President Armstrong spoke and others spoke about Mark Wolff, and so I'm really happy to hear that, because as I was driving in, I'm saying I have to say something about Mark, and so other people have spoken before me, and they've really taken a lot of the words out of my mouth. But in my experience, I was talking to Mark before we came in, and I graduated from this school 22 years ago, and I think since then, before then, after then, you know, Mark has been helping push out really good quality tax attorneys in the community and in the country. So I've seen it personally. I hired these two attorneys not out of law school. I hired Jennifer out of law school, and she grew up and moved away from me. And Lauren, I hired a couple of years ago, and so they're really excellent attorneys. And so I think he's the one who's really encouraged all of us to go on and get LLMs and get this practice. And there's another student in the audience from St. Thomas who I also hired, who's up in the middle. I won't point her out. Yeah, don't stand up, Carolina. So I think that really, I think a lot of recognition goes to Mark. You know, he's the mentor that's fueled a lot of careers, including my own. And so we recognize that. And quite frankly, my own job was my own most important job, which was an international tax job. Mark introduced me to Joel Karp, who passed away, and he was an international tax lawyer. So this is an impact that goes across and ripples across. And so now going to what we're going to talk about. So we're talking about the TCJA, which passed at the end of 2017. It was this major tax legislation. It was very significant in the international area. And what you'll hear from us now is we're really dealing with the ripples of that legislation too. So I'll pass it to Jennifer.
Good morning, everybody. I want to also say a few words about Professor Wolff. I echo everything that's been said here today, including what Stuart said. I think this panel in and of itself shows essentially 3 generations of graduates under Professor Wolff's tutelage and guidance, and I think that's a great testament of the school and the program and the students that we produce. I'm a strong, supporter of St. Thomas, and I really encourage anybody who I meet that's going to school here to really consider going into the tax law field. And to answer your question, Professor Wolff, yes, I still like my practice, and although I'm not going to lie, I'm looking for retirement soon too. But no, it's a great field to be in, and I encourage everybody. And thank you again for bringing us back. It's another great symposium turnout, and really appreciate being here. So let's get started with the content of our presentation. I want to make sure, do we still have an hour and a half? What are we going to? Huh?
An hour and a half.
Okay, so thank you. All right. As Stuart mentioned, we are going to be focusing on the ripple effects of the TCJA on the international side. To give a quick primer on what happened in the TCJA in the international field, it was a great disturbance in the force, if you're a Star Wars fan. And essentially, we went and tried to move to a territorial tax jurisdiction. We tried to accomplish that by having the transition tax repatriate the funds back, and then still allow to have your foreign source profits go untaxed and come back tax-free. As we'll talk about, a lot of those things haven't really played out to be true, particularly with the GILTI tax. Some preliminary comments of where we are now. We're still seeing guidance come out. We're almost 2 years from the law, and I feel like every day we have to monitor the news sources for something new. And it's not just the traditional news sources like BNA and Checkpoint and whatever else is out there. Even the IRS website has to be monitored because they're putting stuff out on the website. So it takes a lot of effort to stay on top of these things, particularly in the international world. So there's a lot of that going on. The other thing that's going on is we're still seeing glitches in the law. People are still discovering these things, and we're still, attempting to bring those out in these type of venues and presentations to put people on notice. And then if you're part of bar organizations or something that can reach out to the government and try to provide comments, we're also doing a lot of that. And last but not least, what we're seeing is fees go up. Clients are not particularly happy with the change of the law. We are reviewing structures, which is bringing in legal fees costs. Accounting fees are going up. This is the first year that accountants are filing tax returns under the new law, and they'll probably tell you it's a very challenging exercise, and they're charging accordingly. And if you're doing some of the things that we do in our practice, we might have to actually bring in and do financial modeling for some of the structures to see which is the most tax efficient. So while maybe the law was designed to save taxes, it's certainly being offset by the additional costs as well. So let's go in This is our agenda. We don't have time to cover everything in the international space that there are updates in, so we kind of focused on what we see in South Florida and go from there. So we're going to go into controlled foreign corporation world, CFCs, for a second. Again, just to gauge the audience, we know some people don't always understand some of these concepts, so real quick, a CFC, a controlled foreign corporation, is a foreign corporation which is owned more than 50% by U.S. persons, and they are subject to certain anti-deferral tax regimes which pick up what we call subpart F income on an annual basis. Subpart F income is, let's just call it, I always call it to clients bad income. It's passive income or income from certain related parties. So we're talking about these type of structures. One of the things that has significantly affected the private client space is the repeal of the 30-day rule under Section 951A. We touched upon this last year for a brief moment, but we were only 4 months, I think, out. And since then, there's been a lot of developments on, let's say, alternative structuring now for the classic structure that we used to do for clients. The 30-day rule essentially allowed us to take a position that on the death of a foreign owner, we could do some planning with the company, such as Checkthebox, within the first 30 days of that taxable year when it was a CFC, and not have exposure to subpart F income to the future U.S. beneficiaries. That rule has been repealed, and now we can be a CFC at any time during the year. And like I said, it's affected our structuring. This was the classic structure before the repeal. It was essentially designed to have a foreign blocker company to hold the passive foreign investments to protect the U.S. stock in the portfolio from a U.S. estate tax, and allow for a basis step up in those underlying investments for the benefit of the future U.S. beneficiaries that would inherit these investments. And we would check the box on that foreign company, like I said, with an effective date within the first 30 days of death, so that we wouldn't have a subpart F income inclusion on the historical gain in that portfolio. Today, with the repeal, if we check the box on that company and not have done certain planning in advance, that historic gain in the portfolio would now be picked up by our U.S. beneficiaries. And so now the conversation with clients is going, how do we structure for them in a way that gets them to what they had before, right? Because clients don't want to change too much. And of course, like I said, they don't want to spend the legal fees either. So we're going to only touch upon 2 of the different structures that I see that the clients are essentially gravitating to. But there's probably 8 or more different ways of structuring out there that's been discussed by practitioners, and we just don't have time to cover all those.
Jennifer?
Yeah.
I mean, we all deal with these things every single day. And Jennifer's going to try and get as much done in 90 minutes as possible.
No, less than 90 minutes.
But I mean, and she said a few times historic appreciation. Just understand that there's a lot of people who live in the United States who have foreign parents, who have all these securities in the United States, Apple, IBM stock, and they've bought it and they've held it for a long time, and there's all this appreciation, and the children are going to inherit those shares. And they want to inherit them generally at the value on the date of their parents' death. But if their parents haven't sold the stock and it has this significant amount of appreciation in it, then the children could, in theory, inherit that stock and pay tax on all the gain that's built in that stock during their parents' lifetime, even though they were foreign. So what Jennifer's talking about is the ways or the techniques that could be done so that those children don't have to pay tax on the income that was earned during their foreign parents' lifetime.
I'm going to skip ahead a few slides and come back to those. So like I said, what are we talking about with clients now who either have existing structures that look like the old structure or are looking to set up a new structure? There's no one-size-fits-all approach anymore. We looked very good to clients up to 2 years ago. We sort of had a magic structure. Now there isn't really a magic structure for everybody. We have to look now closer at the portfolio. And my first question to all clients now is, do you plan to invest in U.S. stock? If the answer is yes, the answer is no, we go back to the old structure and life is simple. If the answer is, well, we still want to take advantage of the U.S. market, I said, okay, well, you could do that by investing through perhaps some offshore funds that are investing in the U.S. market. And those non-U.S. funds would essentially be non-U.S. assets, and we don't necessarily need a foreign blocker company and to protect from U.S. estate tax exposure. So again, we can go back to old structure. Life is simple again. But if they want the flexibility and, of course, to be able to directly invest in certain types of U.S. stock, then we're talking about a variety of options. And what we're seeing the most, I see, is the clients gravitating to this option. This option is essentially a mirror of the old structure, but with an arm off to the side. This really is a pre-repeal structure that we were already doing with clients. The benefit of this structure is that we segregate our non-U.S. assets and from our U.S. assets. And the reason we're doing that is because with the change in the law now, and we have a potential subpart F income inclusion on that historical appreciation, the portfolio, why are we going to increase that amount with the foreign situs assets that aren't otherwise subject to estate tax? Let's get them out to their own bucket and we don't have to worry about that. It also alleviates PFIC issues that we'll talk about in a second. So we segregate those off into its own bucket and we check the box as we would do in the old structure, effective pre-death. So now we can have all those historic gains on those assets be treated as tax to the non-U.S. owner while they were still technically alive, and increase our basis in those assets without any tax. On the other side, we still have this risk of subpart F income inclusion because we have to now check the box effective after the date of death of the non-U.S. owner. Why? Because if we check the box pre-death, we expose those U.S. assets to U.S. estate tax because essentially that foreign corporation becomes transparent. So we have to check after death so that we protect the U.S. stock from U.S. estate tax exposure. However, we have the income inclusion risk. So now we're talking about worrying about monitoring the investment portfolio while the non-U.S. owner is alive and what we call churning the portfolio. Churning meaning we're going to monitor the portfolio for appreciation in stocks, sell them off when they start appreciating and repurchase them if a client still wants that particular investment, and bring them back into a current market value basis. And if you do that and you set up a schedule or monitoring program, you hopefully, when the date of death happens, you've minimized as much as you can of that subpart F income inclusion.
Yeah, I had just a practical, I had a discussion with a client exactly regarding what Jennifer is saying and churning the account. That historically used to be like a bad word where investment managers would buy and sell stocks just to generate fees on trading securities. But today, a lot of the investments of the clients are managed portfolios where the investment advisor is charging a percentage of the value of the assets held in the portfolio. So really, there's no additional cost to churning the account. So I think it's taken it away from the bad word, and as Jennifer's explaining, it's a way to manage this exposure after the death of the foreign patriarch or matriarch.
Right, and what we're doing, at least I'm doing, I'm not sure if you guys are doing the same, Stuart, but we're bringing in the financial advisor to the discussion early on to discuss practical considerations like the buying and selling, what's in the portfolio, what are the costs of churning.
I think that this is absolutely true. And then the other discussion I'm having, and this is just like a this week meeting with somebody, they said, well, how much should we put in the company to own the U.S. assets? How much should we put in the company to own the foreign assets? Does the bank really understand what's U.S. and foreign? And really, we're talking about even you could get even more specific. We're talking about exempt and non-exempt assets. So you might still have even some U.S. assets that are not subject to estate tax in the foreign company. The assets that are held in sort of the foreign security company get this step up in basis because of the death of the individual, and the assets in the U.S. asset company are getting the step up because of the check-the-box planning.
Right. So this structure we're seeing a lot of clients gravitate more to, because you'll see in a second why. Because it's only really the creation of another company, if you think about it. Because if they're already in the old structure, we're just dropping in another company, right? And if these are wealthy people, the maintenance of another company is really not going to be that much for them. And we're also seeing a lot of clients that are under the let's say $5 million portfolio, 5 million or less. There's no magic number there, but they'll stay in the old structure and take their risk and churn as well, because they don't even want to pay the legal fees and costs to do that for that size of the portfolio. Or they'll just get out of stock if necessary. But if they have a significant portfolio and they don't want to churn the portfolio, maybe either because they don't want to have the risk and the financial advisor doesn't want to take on that responsibility, or if there's certain type of investments like private equity investments that you can't easily buy and sell, because you have commitments in those, there's really no way to kind of do that stepping up of basis in the portfolio. So how do you do that and still get the same benefits we would in the old structure? And we're having that conversation with clients about this structure. Now, what does everybody see immediately when they see this structure? It's overwhelming, right? I hope. I mean, I look at it and I still get overwhelmed. So imagine speaking to a client and saying, well, we have this structure that kind of gives you everything you may want, but it's got a lot of boxes on the screen now, right? And there's additional costs involved now. We have definitely much more restructuring involved. We have a lot at stake. But it's good in certain circumstances. We have seen, though, that it really does, you have to justify it. We actually ran some preliminary calculations internally about in a certain client situation where if you don't have a lot of appreciation in the portfolio for whatever reason, it's already churning on its own, the subpart if income inclusion, how you calculate that, and we don't really have time to get into those specific details today, but how you calculate that is really not going to result in that much subpart F income pickup. So you almost have to tell the clients, is that tax that you would pick up really worth it to go through this whole hassle of restructuring? And that's the conversation I'm having with clients today.
Here, just to give an idea, so what Jennifer said, and Jennifer and I were on the phone months ago, we were talking about this particular structure and why we would use this versus the more simple structure, and we talked about the private equity concept. I happen to have some people who are very heavily into private equity, and if you have any kind of history or knowledge about private equity, you buy and you hold for a long period of time. Investment managers are very difficult to deal with as far as selling and repurchasing, and those options aren't there. And then, you know, to sort of get into the exercise of having 4 companies instead of 1 or 2, they do have to justify the costs, and there are a lot of clients who have significant assets who can justify those costs. But even if you use, this structure, what you're really getting at, I mean, in a sort of a best case scenario, right? Well, I would say in a worst case scenario.
Right. It protects against the worst case scenario.
You know, there is the formula that we won't get into great detail about, and I'll just mention it in passing, is generally even in this structure, which is probably the most protective structure that you can have with more cost, is you get like 1 day of U.S. person ownership after somebody dies compared to all the other days during the year when they were alive. And in the first 75 days of the year, you can make certain elections retroactive to the prior year, so you can end up with like a 0 tax cost to the U.S. beneficiaries, or I guess the first year, the only 1 year of appreciation. Whereas anything after the 75th day, assuming you don't take any additional measures and file late and so forth, you start going like on 1/76th of the built-in appreciation is taxable to the U.S. beneficiaries, all the way down to 1/365th. So if the worst case scenario under this structure could be like 1% or 1.2 or 3% of the historic appreciation, people are willing to go into this structure, again, provided there's enough money involved. So it's not a draconian end of the world when you have the subpart F income. It kind of narrows down, but I mean, if you've got people with, even if you have $100 million in there of appreciation, somebody at that level could take a $1 million income hit or $1.5 million income hit and not be that upset about it.
Right. And I would say one of the issues that come up here, I think, and I discuss with clients, is a little bit of risk as well, because in the mechanics and how you're doing the planning with that extra foreign company on the bottom, foreign company 4, certain special planning has to go into that. And in order to do this, you have to rely on certain relief provisions for check-the-box purposes to go back into a prior taxable year, and you need reasonable cause to technically do that. So if you're sort of planning for this, do you really have reasonable cause? Because you're planning for this, right? So you have to be careful of those risks, and I explain those to clients. All right, because in the interest of time, as always, covered some of those points. Nothing really unusual here. Some of these things I've already talked about, but there's other planning considerations that just generally go involved in these structures. I will mention real quickly something that is affecting the structures today is a lot of the historical structures and the new structures have been set up with the foreign corporation in, let's say, an offshore tax jurisdiction, BVI, Cayman, Bahamas. And all of these jurisdictions are continuing the pressure, implementing from the pressure of OECD to have transparency. And one of the new rules is the economic substance rules, and those rules are causing these companies to have substance, which means arguably having employees and an office in the jurisdiction. But you can imagine if all you're doing is investing in portfolio investments, that doesn't really make a lot of sense to have those type of requirements. So we're waiting for some final guidance in some of these jurisdictions to come out to essentially exempt these type of structures from the additional reporting hassles, but it is something we're monitoring in our office, and I think you guys are too.
Yeah, I mean, we're seeing in this OECD effort, so the economic substance is we don't want you setting up a shell company in a particular jurisdiction and not paying tax there. And they're saying unless you have some economic substance, officers, employees, and things like that in the jurisdiction, then you shouldn't really benefit from their, let's say, tax-free system. But they are showing pretty liberal attitudes from what I'm reading on pure holding companies who just hold shares of subsidiaries. I tend to think that's the direction that they're going. However, that's not the end of the story. The OECD is trying to avoid people moving between jurisdictions. So even just this morning, I was reading an article on hybrid entities and people who use entities that are treated as one type of entity in one jurisdiction, another type of entity in another jurisdiction, and that just sort of creates this loophole for taxation. And also the country-by-country reporting and the information exchange. You know, for many years, I think we've been telling clients that the world is going to get much smaller, everybody's going to have information, it's all going to be electronically exchanged. So, you know, don't just think because you're putting your assets in another jurisdiction that the information is not going to get back to your home country, you don't have to pay tax. You got to comply with the laws in your home country. You got to comply with the laws of the United States if you're touching the U.S. And they've learned that, and now that they've really learned it, because the CRS, which is the Common Reporting Standard, which is like the flip side of FATCA, which is an information reporting system that the U.S. developed, is now exchanging information with home countries. And so what I'm seeing in our practice is all of these Latin Americans who for 20 years I've been acting as a goalie to keep them out of the United States, don't come in, don't spend too much time here and so forth. Now they're all saying, look, you know what, the taxes on our home countries are about as expensive as the United States, the information is being exchanged, we're not saving much money staying here, we might as well just come to the United States and pay taxes. And so that's fueling a massive influx of very wealthy clients and pre-immigration tax plan.
Yes. Okay, let's move on. Within the context still of the CFC regime, we also touched upon this issue last year, which is the repeal of the downward attribution rule in the CFC rules. I'm going to try to do this quickly because I have other topics to cover, and we still have to give Lauren her opportunity to cover some of the other important provisions. But essentially, I can tell you today with the downward attribution issues, it's causing literally on a daily basis a call from somebody. Just yesterday, I had a conversation with another advisor about the interpretation of these rules and how they are applying to all client structures. So just use this classic structure for a second. Before the repeal of Section 958B4, which is in our constructive ownership provisions of how you determine what is a CFC. Essentially, you can have, in determining if you have a CFC, you look to indirect and direct share ownership as well as constructive ownership. And we cross-reference the Section 318 constructive ownership rules. Before the law changed, there was a prohibition of attributing or constructively, in this case, in this example, attributing the ownership of FC2 to being owned by the U.S. subsidiary in this structure. And because it said that you do not attribute from a foreign person to a U.S. person. Now with that repeal, essentially, this foreign corporation 2 subsidiary company is deemed owned by the U.S. parent. And now we have the CFC as to foreign corporation 2 on how the operation of the attribution rules work. Because in this case, the U.S. company is deemed to own what its owners own, and its owner is the foreign parent company, and therefore it owns the shares of FC2. This is creating a lot of issues in various structures if there is a U.S. entity somewhere. And we're not just referring to U.S. companies, it could be U.S. partnerships, which is what I was debating with another advisor yesterday on, with a completely different structure that looks nothing like this, and how the constructive ownership rules were causing the U.S. partnership to be treated as causing the underlying foreign corporation as a CFC, and whether or not that needed to be disclosed by the U.S. partnership on the Form 5471, which is the information form that has to be used to disclose a U.S. owner's ownership in a CFC. Now, there's been guidance, limited guidance, coming out on these change in the rules. We were hoping with the proposed PFIC and, proposed GILTI and subpart F rules that Lauren's going to cover would have given us a reprieve. They did not. They only addressed a certain aspect that they turned off downward attribution in the context of 954D3, the related party rule. There is limited relief that came out under the transition tax notice 2018-3, which allowed you to get out of Category 5 filing under a Form 5471 if it was solely causing CFC status by reason of constructive attribution. If there was no other direct or indirect shareholder upstream, then you did not have to file a 5471, and that was the debate I had yesterday with another practitioner, which I believe I was technically correct. But these rules are causing...
I'm sure you will.
These rules are creating havoc because we have to review every structure now for clients to see if there's a U.S. entity causing a problem. Wait. I wish I could see this without having turned in my head. But so now we have more CFCs. with more CFCs, that means we have more subpart F issues, that means we have more GILTI issues. It's also impacting our portfolio debt structures, which in the South Florida community, we do a lot of inbound structuring for investment in U.S. real estate that took advantage of our portfolio debt exemption rule, which allowed us to essentially strip out U.S. income on a tax-free basis to foreign people. If now in our classic structure, which was essentially a foreign company owning a U.S. C Corp, under the technical reading of the constructive ownership rules, the subsidiary company is deemed to own the parent, and how these rules operate. It's a little mind-boggling if you think about that for a second. But if that happens, now I have a CFC, and the payments that I've been making, the interest payments that I've been making, are now going to be disqualified interest payments. So these have blown up our structures, and we've been doing a lot of planning around those structures to still be able to qualify for portfolio debt. I can talk to some people after if they're interested in what we're doing, but in the interest of time. And of course, it's affecting even our private client structures that we just talked about a second ago. So things that we have to pay attention to by virtue of the downward attribution rules. We're hoping the Congress fixes them. A lot of us believe that the legislative history was telling us that it was meant only for a specific purpose and not to affect other types of structures. But as we all know, the political environment these days, it's probably not going to go anywhere very soon. How are we dealing with some of the issues? Is, well, obviously, if we have a U.S. entity in the structure that's causing this problem, think about if we can remove it from the structure altogether, right? If we take that out, then we don't have the downward attribution problem. The other thing is remove the foreign company that's potentially causing CFC status, either liquidated if it's feasible to do so, or check the box on it. All things, though, you have to look at closely to make sure that you're not triggering any additional tax issues when you do that planning. And if you're stuck with having to have either the U.S. company and the underlying foreign company there, then you have to do a lot of the planning considerations that Lauren and Stuart are going to cover to minimize your subpart F and GILTI exposures. And then with that, I'll turn it over to Lauren and Stuart.
Okay. So, GILTI, global intangible low tax income. I think that term is a little bit deceptive, though it's sort of accurate. And what it is that historically, prior to the end of 2017, we had this system where individuals were able to have operating entities and not pay tax in the United States on operating income until dividends were paid. The GILTI system essentially intends to remove that opportunity for the most part on intangible income. And what is intangible income? I mean, it's a fiction. It's a fiction. They take all of your tangible property, things you can touch. They figure out whatever the depreciation is. They give you a 10% hypothetical return on your investment, and then everything else is intangible. So you sort of back into the number, and all of your income over that hypothetical 10% return on your depreciated tangible property is considered to be GILTI, and then that's taxable to the U.S. shareholders. And how is that taxed? It's taxed like subpart F income. What is subpart F income? Again, it was this pass-through type of income, though historically the only type of income that passed through the subpart F income was like passive income for passive companies and like related party sales and service income and some other types of income. So that's the new concept of GILTI. And in theory, if you're taxed on it as it's earned inside the foreign corporation, then you're not taxed on it when it's distributed out to you. But the ways in which individuals are taxed and the ways in which corporations are taxed are different. So now going to the next slide, I'm sorry. We're at a little bit of a disadvantage here. So there's this GILTI deduction that's given to U.S. corporations that own foreign corporations, and through 2025, it's a 50% deduction against the tax at the corporate level. So U.S. corporations today, absent future legislation by a new administration, is at 21%. So 50% of that is 10.5%. And after 2025, there's going to be a lesser deduction, 37.5 of 21 comes out to a 13.125% rate. So in theory, a U.S. corporation that owns a foreign corporation would be taxed at a rate of 10.5% on the GILTI income, regardless of whether it's distributed. Fortunately, U.S. corporations get a credit for foreign taxes paid. 80% of all the taxes paid at the foreign corporation level. So I think if it goes over, 13.125, 80% of that is 10.5. So your GILTI, your foreign tax credit essentially offsets your GILTI completely. So in most foreign corporations that are operating in developed countries where the tax rates are 20, 25, 30%, or maybe even less sometimes, often most or all of the GILTI is offset completely, so the corporation doesn't have to pay tax. And then Lauren can talk about foreign tax credits and how they may not carry forward in that context. Individuals don't get the GILTI deduction off the bat, so they would pay tax at ordinary income rates of up to 37% without any credit. So there is an opportunity for individuals to elect to be treated like a corporation for the moment and obtain a deduction, like a GILTI deduction on this hypothetical corporation that is created by making this election, and you can make this election every year, and sort of offset, again, the tax cost on the GILTI as it's earned, and then when the remainder of the money is actually distributed from the foreign corporation, it's taxed as a dividend, effectively. There is some relief for any additional taxes that are paid at the individual level before the distribution is made if the foreign tax credit is not sufficient to offset the tax on the GILTI completely in the year that it's earned. Now, this slide, I did notice there's a little bit of a mistake, or at least historically. So it says tax due on actual payment of, parentheses, qualified dividend from domestic C corporation. And so one of Jennifer's partners, who I've known since 8th grade, so about 35 years, had the idea that if a U.S. person made an election to be treated as a corporation themselves, in between themselves and the foreign corporation, then they should be treated as a U.S. corporation, and therefore when the dividend is paid in the future from that foreign corporation, it should be treated as if it's going through a U.S. corporation, this fictional U.S. corporation, and therefore be entitled to what's called qualified dividends, where the tax rate is 20% instead of 37%. There was a tax court case that came out that disagreed with that position. I don't know if it's on appeal or not. They're contemplating appeal. Okay, they might lose. However, there is still the ability to get, I thought it was a good argument, quite frankly. There is still abilities to get qualified dividends on these distributions from these foreign corporations, but the corporation themselves have to be a qualified foreign corporation, which is basically a corporation that's set up in a treaty jurisdiction that's on a certain list that the IRS has published. And so from there, I'm going to let Lauren speak because she's much smarter than I am, and so she will go into the nitty-gritty details to let that come out.
So Stuart has explained this new type of subpart F income GILTI that we've been dealing with for the past several years. And I graduated from St. Thomas in 2012 and then got my LLM in 2013. So I had a few years where I didn't have to deal with any of this stuff before the rug got completely pulled out from under my feet and we were all introduced to this new law. So when GILTI came out, which is Global Intangible Low Tax Income, and Stuart just explained how you compute the GILTI, there were a number of questions and comments by tax practitioners in the United States wondering, okay, how do we deal with this new type of income? There were a lot of open questions, a lot of planning opportunities that we weren't sure if they would or would not work out. And so there were regulations issued on June 14th, 2019, in the form of final, temporary, and proposed regulations that dealt with GILTI, that dealt with subpart F income, which is the income we discussed before, and Jen was mentioning the passive income that's deemed distributed even if it's not actually distributed, and then also dealing with the dividends received deduction under Section 245 Cap A. So what did these regulations give to us? What gifts did they provide in the form of guidance so we can figure out what we're doing with this type of income? I'm going to go through some of the main provisions of these proposed regulations because we would be here until 9 p.m. if we went through everything in detail. But I'm going to touch on some of the highlights that hopefully make sense for your practice. One of the main items within the proposed regulations was the treatment of U.S. partnerships for GILTI inclusion purposes. Under the proposed regulations that came out prior to June 2019, there was a rule that was going to treat U.S. partnerships under a hybrid approach. What does that mean? That would mean that sometimes they would be treated as an aggregate, meaning you would look through to the U.S. partners or the partners of the domestic partnership holding a CFC, and sometimes it would be treated as an entity, which means it would be a separate taxpayer, separate entity for tax purposes to determine whether you would have a GILTI inclusion, and also questions arise as far as a subpart F inclusion. So what the final regulations for GILTI said, we're going to treat the U.S. partnership that owns a CFC as an aggregate. So you're going to look through to the partners to determine the pro rata share of GILTI inclusions, and even we'll get into subpart F inclusions as well. So this rule really was helpful to determine when you're going to have an inclusion, you're going to look to the partners. Now, you're not going to use this rule for purposes of determining whether the foreign corporation is a CFC under the definition that Jen gave us earlier, and you're not going to determine whether the U.S. persons are U.S. shareholders for purposes of CFC determinations. But you are going to use it for GILTI inclusions, and also under proposed regulations, you're going to use it for subpart F inclusions. So that is helpful in determining whether you have GILTI or subpart F. So essentially, this rule exempts domestic partnerships from GILTI inclusions under the final regulations and from subpart F inclusions under the proposed regulations. Another item that the GILTI regulations touched on was they narrowed the scope of pro rata share. There was a pro rata share anti-abuse rule that had been introduced. It was a very broad rule that essentially said if you had any transactions that were to reduce your tax or your pro rata share, that those would be disregarded. And it would basically go in perpetuity. So even if you were to sell the stock in a later year, you could potentially have this anti-abuse rule coming into play. It was extremely broad, and there were a lot of comments that came out on it because it really honestly didn't make sense. So what these regulations did was they narrowed this rule so it only applies for the CFC's taxable year, and that's determined on the last day of the year that it's a CFC. So that's what you're going to look to determine the pro rata share of the subpart F. This came out under the GILTI inclusion regulations. And this will go into the computation of GILTI because as Stuart was defining, you would take out any subpart F income inclusions to get to your GILTI inclusion. Another item that these regulations touched on were they abandoned a proposed tested loss recapture regime. Basically, this was a regime that was going to reduce the basis of any CFC stock. We're not done with this, though, because they did say within these regulations that they will be handling it on a separate project. So it's not done forever. It's just not being dealt with at this point in time. So as Jen mentioned, we are continually checking our inbox every day, every night, every morning to, weekend, whatever, to determine what the new rules are as they come out at fairly rapid pace, it seems like. Another item is there's an election to eliminate disqualified basis. This goes back to the computation for GILTI and one of the computations that Stuart was touching on, QBI, to determine what your GILTI inclusion is going to be, and that ties into the foreign tax credits that we'll touch on in a few moments. The regulations also clarified some of the interactions between the subpart F income, which was the passive income that we've been dealing with for many years, and the GILTI income, which has just come out under the end of 2017. Just for the sake of time, I'll touch on just a few. They confirmed subpart F income resulting from a 952 recharacterization under the subpart F rules is not gross income in determining the subpart F income, so it could be potentially a double inclusion under subpart F. And when you're computing your GILTI as well. It modified the definition of specified tangible property. That's what Stuart mentioned when he was explaining how you actually come to your GILTI inclusion. To exclude income items typically considered intangible property, namely computer software, qualified film and television productions, theater productions. There were some questions as to how do you define tangible property for the purposes of determining GILTI. The final regulations did not add a general exclusion for high tax income, except we do see that there is, I'll be touching on in a moment under the next slide on the high tax kickout. And there's some anti-abuse rules that I won't get into, but we can talk about it after if you would like to go into it further in the interest of time. And I think, Stuart kind of touched on this a bit for the high tax exception. So under Code Section 951 Cap A, which is the GILTI provision, U.S. shareholders of CFCs, which we have defined, can elect to exclude the CFCs items of gross tested income, so the income that you're determining the GILTI inclusion, that is subject to foreign income tax rates that exceed 18.9%. So essentially, that's greater than 90% of the current corporate minimum tax rate of 21% that came out at the end of 2017 under the TCJA from the GILTI inclusion. Just a few tidbits on the high tax exception. It's excluded from the GILTI inclusion when you're calculating that amount. Corporate U.S. shareholders can repatriate tax-free. Non-corporate U.S. shareholders can repatriate at either a treaty rate of 23.8 or a non-treaty rate of 40.8. It has to be made, this high tax exception, by the controlling U.S. shareholder. It did not, the final GILTI regulations did not extend the subpart F high tax exclusion to GILTI. So subpart F also has its own high tax exclusion provision. The regulations confirm that will not be extended to GILTI itself. What else can I tell you in the sake of time? And as Jen mentioned, we are now having to sometimes do financial modeling to determine whether this high tax exception actually applies when you're computing your GILTI amount.
I think a lot of the tax community found this to be a favorable provision in the regulations because a lot of us who were trying to restructure some of the outbound structures for clients, we're trying to actually now structure into subpart F income inclusion under the CFC rules to take advantage of the subpart F's high tax exception rule. And now this kind of helps in not having to go through all those restructuring hassles for clients and the costs associated with that.
Yeah, I think you're talking about the high tax exception for GILTI. There are proposed regs that would allow that. When they finalize the proposed regs, you're only going to get that exception until the year after they finalize them. What I'm finding is that in my practice, thanks, Professor, sometimes it's not a good idea to make this exception. The way that they drafted it's really broad. So you have to make the high tax exception for GILTI for all your CFCs. And if you're relying on foreign tax credits to offset the cost in the U.S. of your GILTI inclusion, and you make the high tax exception, you're not able to use those credits anymore. The credits aren't deemed paid. And so if you've got some mixture of really high tax earnings and low tax earnings, you make the exception. You don't have the inclusion of those high tax earnings. You lose the foreign tax credits. Now all of a sudden you are subject to U.S. tax on your low tax GILTI earnings. And I've got other clients that are relying on the GILTI inclusions for 163J interest deductibility capacity. And you could lose that if you make this election as well. So.
Yeah, no, I'm not saying that it's the solution to every client situation. I'm just saying it was a very helpful provision.
Yeah, I think that's a very good point. We're doing the modeling to compare the using the foreign tax credits versus the high tax exception. And then with regard to subpart F, it's funny, Jennifer's talking about trying to back into subpart F for the high tax exception, which is not necessary anymore. There's also the foreign tax credit advantage in subpart F, which Lauren can mention as well. Okay. This is my slide. Let me real quick. I mean, this is the 962 election, which I talked about before, where an individual elects to be treated as effectively as a corporation for purposes of taking advantage of the GILTI deduction. I don't think I need to go through it again, so I'll let Lauren continue.
Okay, so let's continue with our review of some of the new regulations that we've received. These are the proposed regulations dealing with the foreign tax credit. So just very high level, a foreign tax credit essentially is basically when you have a U.S. Person that is taxing your foreign source income of a U.S. taxpayer, there's a reduction of credit for that income. The way that you calculate it is you would take all of your foreign source taxable income over your worldwide taxable income and multiply that by your U.S. income tax liability before the foreign tax credit. And that's how much you're going to get the U.S. Income attributable to the foreign tax. And that's how you calculate your foreign tax credit. We recently did this for a client where we had to model out what the amount of the foreign tax credit would be. And we also brought in some treaty issues, which I'll talk about in a bit under these regulations as well. So these regulations came out on November 28th, 2018. These are proposed regulations that provide guidance to determine the allowable foreign tax credits, which I just defined for you. There were a number of questions that came out under the new tax law as to how these foreign tax credits applied with the changes with the foreign tax credits and also with code sections that we've had around for a while, such as income from sources within the U.S., limitations on credits. But how do we deal with these when we're dealing with the GILTI and all the new tax provisions that we're dealing with under the TCJA? So some of the items that were touched on within these proposed regulations, there's two new baskets, essentially, and I'll go into the baskets in a bit, but for many years we only had to really deal with two baskets for foreign tax credit purposes. When you're calculating the foreign tax credit, you would basically look at one of these two baskets, either the general basket or the passive basket, and the income would either flow into one or the other, and that's how you would determine your foreign tax credits. Under the proposed regulations, we now have two more baskets. There's one for GILTI and there's one for foreign range income, which I'll get into in a bit. There's also a number of provisions within these proposed regulations that deal with how you calculate the foreign tax credit, for example, for GILTI when you have the code section 250 deduction that Stuart was going over. How do you calculate the foreign tax credit? So some of the provisions dealing with that, the regulations say there's a gross income offset for code section 250 deductions. They're treated as exempt income, and any stock that gives rise to a GILTI inclusion is treated as a partially exempt asset for purposes of allocating to the different baskets for the purpose of GILTI. There's also provisions dealing with one of the provisions that we didn't talk about much today, which is the foreign derived intangible income, FDII or FDII. That's another type of income that we are dealing with under the Tax Cuts and Jobs Act. The regulations also provide provisions to deal with the calculation of the foreign tax credit when you're dealing with the FDII type of income as well. So basically, one of the main provisions of these proposed regulations is how to actually, what amounts are going into the income to determine this foreign tax credit, what's going to be treated as income, what's exempt from income. And some of these provisions are helpful. They do provide relief, and they do allow you to receive the foreign tax credit on some of these GILTI income and FDII. They also provide new CFC stock characterization rules, so they allow you to allocate and apportion deductions for the purpose of Code Section 904 for the foreign tax credit, and they provide different methods to determine what your deductions are going to be. There's an asset method, which basically the regulations gave us 5 steps to use the asset method, and there's also a modified gross income method that you can use. The regulations also deal with various allocation rules for determining the foreign tax credit amount, dealing with research and experimental expenditures, partnerships and CFCs, and affiliated group rules as well. So there's a number of provisions that needed to be re-examined with all the types of new income that we're dealing with. So going into the 2 baskets, I think this is something that's kind of a hot topic for foreign tax credits. So there's, as I mentioned, the new GILTI basket and the new foreign branch basket. Stuart kind of touched on this, but when you're dealing with the GILTI basket and you're dealing with the foreign tax credits, you're not going to be able to have a carryback. So there was an issue where you weren't, practitioners weren't sure how to calculate the foreign tax credit when you have GILTI, and there are issues now that you can't carry that back. There are provisions now within the foreign tax credit regulations that are proposed dealing with carryovers of unused foreign taxes, and there are provisions that do allow you now to carry forward any pre-2018 foreign tax credits that you're dealing with under the GILTI provision, taking into account GILTI from last year to carry forward some of those provisions. So when you look at the foreign branch basket, I don't know if you want to touch it at all. I know you both kind of mentioned for GILTI with the foreign tax credit, but basically for the GILTI, there's just, as I said, you can't carry it back, but there's a number of provisions for carryover of unused foreign taxes that came into play with the new GILTI rules. The second basket is the foreign branch basket. Foreign branch income deals with qualified business units. Qualified business units, or QBUs, have been around for quite a while, but we now have a new basket for the foreign tax credits. Basically, the QBUs are treated as separate, not taxpayers, but almost like a separate transaction for a U.S. taxpayer, and they have this type of income, foreign branch. It's defined as the business profits of a U.S. person that's attributable to a QBU. So essentially what these proposed regulations did was they provided guidance on how to, A, determine the foreign branch, if you have one or not, and then determine whether you have foreign branch income attributable to that QBU. They modify the QBU definition where you first it only relates to trade or business for purposes of the foreign branch basket. They have to be outside the U.S. The activities have to give rise to a permanent establishment in a foreign country under a relevant U.S. tax treaty. They're presumed to be treated as a trade or business. Disregarded activities are considered in determining whether a trade or business exists. If it's a partnership or trust, then it must have a trade or business, and separate books and records are not required for partnerships and trusts to constitute a QBU. These regulations also provide that if you have gross income attributable to a foreign branch, that it's reflected on separate books and records of the foreign branch, but excluded the following items of income from that foreign branch basket. Items of income from activities carried on within the U.S., items of income arising from stock, including subpart F inclusions and GILTI inclusions. Those would be dealt with under either the GILTI basket or most likely the passive income basket. And there's more on foreign books and records as well of the QBU, but essentially it's interesting that there's now these 2 new baskets, because when we're dealing with the foreign tax credit, as I said, we're dealing with it for a client right now, you now have to take into account these other 2 baskets as well, which we never had to deal with before. One of the most interesting things that I thought came out under the proposed tax credit regulations are for items of income that are resourced under a treaty. So if you have a U.S. income tax treaty with a foreign jurisdiction where the treaty provides that you can actually resource the income that's treated as U.S. source to foreign source in order to get a foreign tax credit, there's new provisions under these proposed regulations that deal with these items that are resourced under the treaty. The rules in the code section that existed before the proposed regulations are under code section 904 D6. This was enacted to create a separate 904D basket that was under the other basket, so it wasn't a completely separate basket, for each item of income that is U.S. sourced under domestic law, that's resourced as foreign source, as I said, under a relevant income tax treaty, and that the taxpayer is actually making an election to benefit from such treaty and be able to take the foreign tax credits. What these proposed regulations said is that the items of income under the same treaty can be grouped together, so that does make it much easier to compute the foreign tax credit rather than requiring a separate basket for each type of income under the treaty. And they also clarify that this resourcing can also be under competent authority agreement. So basically what they're doing is they're saying, you know, you can actually resource this income, and they provide the rules in order to do so. You have to file a form 1116 in order to take the advantage of the foreign tax credit, and also a form 8833 in order to take a treaty position, such as resourcing income under the treaty.
Okay. All right, so that last piece on resourcing treaty is probably one of the most complicated technical analyses that we've had to do in a while. This was a case involving Canada, which involved the trust distribution in the first 65 days of the year, which was elected to be effective as of December 31, was elected to be effective as a disposition, which had these gains, which went to a U.S. person, which had to be resourced, which now fell into the foreign tax credit basket. So I congratulate Lauren for pulling that apart like a chicken, okay? So back to easy stuff, transition tax, okay? So the transition tax was basically a way when the U.S. When the new legislation came out at the end of 2017, we said, okay, going forward, we're going to start picking up all the income that you're earning offshore, whether it's subpart F or it's operating income with certain exceptions and certain foreign tax credits and so forth.
You got 30 minutes left.
That's more than enough time. But then they had to say, well, what are we going to do with everything that came before? And they said, well, let's just tax it all. All right, so that's what they did. And they said all of your, essentially your earnings or profits or your retained earnings that you've accumulated up to this point, really from like 1986 forward, I believe it was, we're saying, okay, we're gonna pick all that up and we're gonna tax it. But we're gonna give you some benefits. We're gonna tax it at lower rates than usual. We're going to give you opportunities to pay the tax over an 8-year period with no interest. And in some cases, we're going to give you a chance to defer it almost indefinitely. And they even let us look at all of the foreign corporations that were affecting particular U.S. shareholders. And some of those corporations had losses and some of them had gains, and so we were able to offset losses and gains. And then the effective tax rates were different for individual shareholders versus corporate shareholders. So all of those were called deferred foreign income corporations. And so everybody got to the end of 2017, and the accountants got all crazy and had to figure out how to pay taxes in the beginning of 2018, and they were afraid if they didn't pay the right amounts that they were going to lose the opportunity to pay the tax over 8 years, and this still goes on to this day. And what it did do is it basically said, okay, everything that came before is really going to be considered previously taxed, whether you paid tax on it at the end of 2017. Whether you elected to defer paying tax on it for 8 years and you paid it over like 8 years in sort of unequal installments. I think it was 8% for like 5 years and 15, 20, 25, I think is the way it goes. Or if you had an S corporation and you deferred your tax like forever until certain triggering events occurred. So that allows all of those foreign corporations to push up all of that those retained earnings, essentially tax-free is what they call previously taxed income, even though technically the tax may not have even been paid yet. So that was a very good thing. The rates went between, I think, 8 and 15.5 for corporations, or between 9.1 and 17.5 for individuals on this accumulated income. And that accumulated income, you actually did better if those accumulated earnings had been reinvested in some business assets and not cash or cash equivalent assets. They said, all right, the tax on those accumulations would be taxed, let's say in the case of an individual, at the 9.1% rate. In the case of a corporation, at the 8% rate. And if you had just cash sitting there like Apple and you decided you weren't going to send back $4 billion or however much money was sitting there, they were going to tax the cash at the higher rate. And they did. It was taxable, but like I said, the tax may not have been paid. The only thing you have to remember, I think, is that when you distribute the money up the chain, you end up picking up also the net investment income tax of 3.8%. So that was how all of these things occurred. And now what we spend time on with clients is, when am I going to pay my transition tax? Am I going to accelerate the payment of my transition tax? How am I going to find the cash to pay back my previously taxed income? And what am I going to do after I pay back all my previously taxed income? Because we have some clients who have, there's one particular family that I have in mind, which is from a Central American country. They're U.S. citizens, they live in that country, and they have a bunch of operating companies in that country. And so after all the previously taxed income comes out, and it pretty much comes out first, and it comes out tax-free, they're going to say, okay, now we're going to start paying dividends going forward, or we're going to have GILTI. What are we going to do? And at that point, people start to think about how is this GILTI going to be taxed on an annual basis? These people are individual shareholders, so they're not corporations. So they have to decide: are they going to make what I was talking about before, this 962 election every year, to be treated as a corporation and get a credit for the foreign taxes paid in the foreign country, or are we just going to drop or contribute the shares of these foreign corporations into a U.S. corporation now and really put a U.S. corp in between themselves and the foreign corporation? And why would they do that? They would do that because the U.S. corporation that they insert in between would be able to get the foreign tax credits that we're talking about. Dividends can be paid tax-free to the U.S. corporation because there's what they call dividend received deduction now. And dividends that are paid from the U.S. corporation to themselves later on would be qualified dividends eligible for the 20% rate versus, let's say, 37% rate because these companies are in non-treaty jurisdictions. So this is, again, sort of the ripple effect of the TCJA. Where are we today? What happened at the end of 17? How are we going to clean up the previously taxed income? And what are we going to do going forward? Really with some uncertainty, because today the U.S. corporate tax rate is the best it's been, what, ever? 21? And so everybody's afraid that if there's a change in the administration, there could be a change in the tax laws and the U.S. corporate rates could go up. And one of the advantages of the 962 election is that you could make that election every year, whereas if you put yourself into a corporate structure, you're locked in. So if the tax rates go up in the corporation, you could be locked in at a higher tax rate. And I'll move it to Lauren. I guess, Lauren, you're going to talk about some triggering events, all right?
So, like Stuart is saying, there was certain planning that we could have done in order to defer or mitigate this transition tax. Some of the planning that we've done is, as Stuart mentioned, if you have an ESSA corporation that's a U.S. shareholder of the CFC, then you can elect to defer the tax until a triggering event. So what is a triggering event? They're defined as failure to make an installment payment if one is in fact due, which it wouldn't be if you have an S corp, but if you do have an installment payment and you don't make it, that would be a triggering event, which would essentially cause you to recognize all of your transition tax in the periods that Stuart mentioned, liquidation, sale, exchange, or disposition of substantially all of the assets of the taxpayer, which makes sense because then you would be getting out of the jurisdiction of the transition tax, so at that point it would be imposed. A cessation of the business itself, change of the individual status of a U.S. person, so if they became a non-U.S. person, again, they'd be getting away from the U.S. income tax system, so it would make sense to subject them to tax under this transition tax. Death of the taxpayer, joining a U.S. consolidated group, and deconsolidation of a U.S. group. So if you have one of these triggering events, they may not cause the transition tax liability to be accelerated or triggered if you have met certain requirements. Essentially, the code provides for a transfer agreement that can be entered into within 30 days of an acceleration or triggering event in order to avoid the acceleration or triggering of this transition tax. The transition agreement is made by making a Section 965I election, and it's only eligible for certain triggering events. If you do want to make this election, then if you're eligible, the eligible transferor must attach Form 965 Cap A or Form 965 Cap B to the transfer agreement. The forms that I just mentioned are not due until the due date of the 2018 income tax return. So we're here, guys. It's happening. And the final regulations also provided relief for taxpayers who made a Section 965A or 965A election for their 2017 transition tax liability, so either a deferral or a mitigation of that transition tax.
Thanks. And on the triggering event for death, didn't they have something in the notice that at least allowed some relief from that if you entered if the beneficiaries of the estate entered into the transfer agreement? Yeah, because we were concerned when that first came out that death is going to cause the transition tax to be paid, and of course, if there's an estate tax on top of that, that could be a double whammy for some clients. So it was something that we were initially concerned about. Okay, so moving on. This, interesting enough, we're going to talk about something that's just recently come out, which is some regulations in the PFIC area, or Passive Foreign Investment Company area. They, there wasn't really much in the PFIC area as part of TCGA, but I think as a result of some of the regulations that have been proposed in the GILTI and subpart F income area, they were forced to issue these regulations to address some of the overlap of the different tax regimes that we have between the PFIC rules and the CFC rules. Not to mention, there was just a lot of time that has passed by since we haven't received any guidance on the PFIC rules, and I think the IRS took some of these issues into consideration and issued regulations in July 11th, 2019, to clarify a lot of things that were in doubt with these rules. But let's take a step back for a second and just quickly explain what a PFIC is. A PFIC is a non-U.S. corporation, which can be owned by any percentage of ownership by a U.S. person, but how they determine whether it's a PFIC or not is based on the income or the assets that the PFIC has. So if 75% or more of the foreign corporation generates passive income, it's a PFIC. Or if 50% or more of the assets that it has is passive assets or can generate passive income, it's a PFIC. So we always discuss with clients that the classic situation of a PFIC is a foreign hedge fund, right? You have a foreign corporation, most often set up offshore, and they're investing a bunch of passive investments. That is the PFIC. But PFICs come in all shapes and sizes. That's not the only one. And sometimes if you are doing business outside of the United States, in the outbound context, sometimes your CFCs could trip wires accidentally and become a PFIC. So it's not just in the passive investing world that you can have a PFIC, but you can be potentially exposed to these rules as well if you have a business operation outside of the United States. In the interest of time, as always, The general reaction of these rules is they are fairly taxpayer friendly. On the slide there is sort of a summary of the main takeaways from these rules. I think the biggest one that was helpful to us is how you define passive income. Before these regulations, all we had was the code telling us that you look to, by cross-reference, 954C in the CFC rules, which is foreign personal holding company income rules. But many of us weren't sure that by the cross-reference, did we include all of the 954C rules, including the exceptions, and applying these tests or not? So these rules came out and kind of gave us a little bit more guidance to tell us what part of 954C we will use in determining passive income and which parts we will not use. The parts that we will not use are really excluded because in the preamble to the regulations, they basically said some of these things we already have in the PFIC rules, so it makes no sense that we're going to give you 2 bites at the apple to exceptions under both rules. So, for example, there is a look-through rule under the CFC rules. The PFIC rules have their own look-through rule. So they said, no, you're not going to get the benefit of the CFC look-through rule. You have to just solely rely on the PFIC look-through rule. They did clarify, I think this was very helpful in the context of the active rents and royalties exception, which is also, again, cross-referenced by 954C. Under the CFC rules, we, again, had issues about whether or not a company, let's say, that was investing in a real estate development project outside of the United States. I have a client situation right now where it's in the pre-immigration context, but they will be U.S. They have an offshore company that owns a Colombian company, and they're investing in Colombian real estate development. So we are analyzing whether that's a PFIC or not, and so under the CFC rules, if you looked to the CFC rules to analyze this, they would basically tell you you wouldn't qualify for the active rents and royalty exception on your, let's say, rental income in my example, if essentially the officers or directors are not employed by the company that owns the real estate itself. So in my case, my client was using a third-party manager to basically run a lot of these things, so it wasn't going to necessarily qualify. These rules came out and were pretty liberal and expanded on the CFC rules to basically now allow a situation where if you have a parent company owning a subsidiary company, let's say, that owns the real estate, and there's another sister subsidiary company that maybe is doing the management and has the employees or whatnot. The parent company, if you're testing that for PFIC purposes, can now attribute that other foreign company's activities to the real estate company and potentially not be a PFIC, and that's a real big benefit. Unfortunately, the rules tell you that they're not going to apply it sister brother, and they're not going to apply it up downward either. So you have to look at your structure still to see if you fit in, but I think that is a good thing, and if you are structuring from scratch, you have a good sense of where you would go in structuring some of those outbound real estate structures. There was some interesting rules on domestic partnerships. There, again, I think they were trying to carefully address some of the things that were addressed in the CFC and GILTI proposed regulations. This idea of an aggregate approach on a lot of things. So, for example, in determining whether or not if a PFIC is owned through a partnership, you would look through. There wasn't a similar analog provision in our rules attributing that. So now there is a new rule that you would look through and apply, just like our 25% look-through rule that we have for companies. Makes sense, but it wasn't there before. What else can I tell you? Oh, what is interesting is that if there is a 25% in a partnership interest, sorry, the U.S. person owns 25% or more in the partnership, then they will say that you look through. But if it's less than 25% owned, then they'll tell you that the interest in the partnership, or sorry, the interest is deemed to be a passive asset or a passive income, depending on what you're testing for. So you got to be a little bit careful in that regard. The preamble says that they're asking for comments in that area to see if it makes sense to have a threshold like that. So we'll see what comments produce. How are we doing on time? Yeah, we still have 2 more. Again, just some preliminary comments because we are still digesting a lot of these rules that just came out a couple months ago and seeing how they apply in some of our structures. The good thing is in the first slide, they are allowing, the IRS said that we can apply these proposed regulations now if they sort of suit our needs, but otherwise they're effective when they're finalized. The interesting thing going to the aggregate approach, it is a general theme that we're seeing more with partnerships, and that does raise an issue of whether or not our foreign partnership structure that we often would use for estate tax purposes as a blocker, whether that still is a strong enough structure after some of these regulations are coming out and looking through. I'm still of the view that I think there's a good position when needed for a foreign partnership to be a good estate tax blocker, but I can see why people are getting a little nervous with a lot of this aggregate approach coming out. I don't know if you have any thoughts there, if you're still feeling comfortable with foreign partnerships, Stuart?
Yeah, I think that what Jennifer's alluding to, if you're not familiar, is that we use partnerships, foreign partnerships, in real estate investment structures historically for many years. As estate tax blockers, taking the view that they were not subject to estate tax because the entities were formed in foreign jurisdictions and that the owners of those entities were foreign residents, and so what they owned was an intangible asset and it was sited outside the United States. And then now you have these, like you said, the concept of partnership being treated as an aggregate and looking through, and so that does, I think, give us more pause in using it, but that's also combined with the fact that the corporate tax rates have gone down. Mm-hmm. So now, you know, the difference in the tax rates between corporations and partnerships is a much smaller spread. So to get a better, or let's say more secure estate tax protection position, we're leaning towards corporations. Yeah. That said, it's very hard to take those existing corporate structures, those partnership structures, and convert them into corporate structures because of certain inversion rules. And so I don't have a great solution as to how to transition from partnership to corporation. So the historic structures that exist where we're using partnerships as blockers will continue to support that position because I still think it's a feasible position. But going forward, we are leaning more towards corporations for those same reasons.
Yeah, we're doing the same. The other interesting thing to note is Lauren covered how the proposed regulations in GILTI and subpart F addressed domestic partnerships and their treatment now in determining and testing for GILTI purposes in subpart F. And now you have sort of this, again, look-through approach going upward, right, and testing for inclusion. And now there's a risk to those minority shareholders in a domestic partnership, and minority being, in this case, less than 10% owner, that the U.S. partnership is no longer serving as a potential blocker, if you will, for CFC testing purposes. And now, because of these rules, we're looking through, and you may now have PFIC problems, but depending on what the foreign corporation is doing or not doing. So why that's important is under 1297D, there's an overlap rule that essentially says if you're both a CFC and a PFIC, you're taxed and treated under CFC tax regime, not the PFIC rules, which can be a little bit favorable in some cases. But now, because of these look-through issues, our minority shareholders don't get the benefit of the domestic partnership blocking you. And now you have to look downstream and see if they're subject to the PFIC rules, because they're not going to be a U.S. shareholder for CFC purposes. So that's a big issue that's going to start coming into play here, I think, in the near future. And last but not least, what the regulations did not address is an issue that's been out for us for a very long time, pretty much since I started practicing, and I'm sure it was already there when Stuart started practicing a little bit, and that is how to attribute through a foreign non-grantor discretionary trust. We were hoping that the regulations that came out would give us some guidance there, because there's a lot of people that take positions in this area. Sometimes they're aggressive, sometimes they're conservative. But it's not clear through a foreign non-grantor trust that's wholly discretionary who are the beneficiaries for purposes of attributing ownership. And that can become a big deal in the context of whether you're a CFC or if you're a PFIC. And that was left unaddressed in these regulations.
I'm going to touch on a new code section very briefly, because I know we're running out of time and we want to get to our ethics portion of the presentation. There's a new code section, 267 Cap A, that effectively denies a deduction for any interest and royalties paid to related parties in connection with a hybrid transaction. So essentially this means that if you have any related party income that's being paid and you're trying to get a deduction via this related party transaction, there may be a denial under this new code section. The purpose behind this code section kind of goes to what both Stuart and Jen talked about, how the world is becoming much smaller and global at the same time. It was introduced in response to concerns in the international community that hybrid arrangements were being used to achieve double non-taxation. So effectively, if a type of income isn't taxed in either jurisdiction based on the way that the company is formed or the jurisdictions in which the company is formed. And that is the purpose of this new code section. If you have any questions about it, we can chat about it after. Should we do it? Yeah.
I'll just make one comment on the 267A hybrid transaction issues, is that going back to the portfolio debt structures that we were using for inbound real estate structuring, going back to my downward attribution problem, where people were concerned that that was going to turn off the portfolio interest debt exemption, because we now have a CFC. Some people were being conservative and planning around that. One way of planning around that has been maybe checking the box on the foreign company and to make it a partnership. So that would take you out of the downward attribution problem issue, and so not having a CFC. And but that was raising issues in the context of 267A, whether or not we were going to be stuck with this prohibiting a deduction. And I think the regulations were favorable in the sense, at least our firm believes that a BVI company is still can be used as a good jurisdiction because under BVI law, even though there's zero tax rate, there's still technically corporate tax there, and you include it in the income, but it's just not taxed. And so when you look at the regulations, they seem to be looking at inclusion as opposed to your effective tax rate. And if you're still concerned about, let's say, BVI being a little aggressive still in that context, we're vetting out, the use of other jurisdictions that have lower tax, like Hungary. You can get an effective tax rate of 9%, and so you're still getting this inclusion, but with a fairly low tax rate.
Okay, so that position Comes out of the same colleague who was challenged in the U.S. tax court, so
That's why I said it.
take some caution in taking that position. Not that I disagree with it, and I think that they're novel ideas, and I think that technically there's accuracy there.
Yeah. All right. Now, it's important, the brochure told you you're going to get some ethics and technology credit today. So we were noodling on what would be a good topic in the context of international. So this was something that I came up with because it's something I address on a daily basis, and I think Lauren and Stuart probably do too, is, we are U.S. tax lawyers at the end of the day. We're only licensed to practice in the jurisdiction in which we're barred. We have duties of competency, but at the same time, we can't practice law in another jurisdiction. So when we're working with international clients on cross-border issues, we have to engage foreign counsel, right? To tell us what the laws of that other jurisdiction tell us, because we can't tell the client. So the issue comes in is we know that we have to protect our clients' confidential information. Our bar rules tell us that's a very strong thing that we have. One of the strongest things that we offer to clients is the duty of confidentiality. But the question is how proactive do we have to be when working with foreign counsel and making sure that they are taking steps to protect client information that you may be sharing with them? Right? And everybody's probably heard by now the Panama Papers and the Paradise Papers. Well, these were two law firms, one in Panama and one in the Cayman Islands, pretty prominent ones of which over time I think Stuart and I had some interaction with. Luckily, none of my clients fell into any of those leaks. But the point is they were hacked. These law firms were hacked, and now these secrets were out, if you will, for everybody to see. And we work a lot with clients that have real security risks. A lot of our clients are from Latin America, and there's political turmoil in some of these countries. I mean, just look at Venezuela right now. I mean, there's safety issues. We've had clients where their children have been kidnapped and held for ransom. So the fact that you're working with these clients and now they're subject to these potential leaks that could get out, this could be a real at the end of the day, issue, a life or death issue for some of these clients. So when we're working with these foreign lawyers, we have to make sure that that information is not at risk of being exposed by a hack or some other means. And you'll be surprised, clients who come from Central and South America, they don't even have a lot of trust in their own local advisors. Right? They feel that they're somehow tied to the local government and corrupt. I mean, I just had a client the other day who wanted to get who wants to get some inbound planning advice and pre-immigration, and I always have to make sure that that we're doing everything properly, and we have local counsel to the extent we need it. And I think it was Guatemala. The client, I said we have to engage Guatemalan counsel, and she's like, I don't want you to work with anybody in Guatemala. So how do you handle that situation? You handle it by the best you can, saying we have to get local advice. We'll see what we need advice on specifically, but maybe we can work on a no names or hypothetical basis with some of these foreign lawyers, so at least your name and sensitive information is not being shared with these foreign lawyers. And so the rules tell us, surprisingly, I mean, they don't tell us specifically what we're supposed to do, but it's clear that we have a duty to make sure, under our duty of competence and duty of confidentiality rules, that we have to, when just working with these foreign lawyers, ask them what protections do they have in place for potential breaches, so that we don't have another Panama situation at hand. And I think that at the same time, we also have to have conversations with our clients about how much information we can actually share or not share, and get informed consent from them to the extent that we feel that it's a really high-risk situation. In some cases, maybe we're not sending anything over the internet, right? You'll be surprised. Clients, advisors will travel to the United States to take in-person meetings because they themselves are fearful that somehow that information will be leaked. So we have to be extra careful and cautious because our professional responsibility rules tell us to do that. And while there's no explicit black and white rule, what we're supposed to do, the ABA did come out with an opinion not that long ago. There you see, it's in the context of cybersecurity threats, but I think it's a good, it addresses this issue. And they don't come out to give you an explicit black and white, this is what you have to do. They tell you you need to take reasonable steps and here's some things that you should be thinking about doing. So I'm not going to go through all of those. But I think when you look at the last one, when it's talking about you have to see if the vendors that you're working with, I think in that context they were thinking more like if you're using a third-party appraiser or some other type of non-lawyer situation, that you have to see how they have their security protocols in place. But I think that's easily can be applied to a foreign lawyer, right? So I think we have it there that we need to be extra cautious about these issues now, and our technology credit would tell us that we have to be more familiar with technology, and I'm telling you, I am so much technologically inept. I feel like I'm definitely my parents now. I remember when my parents used to tell me, I don't know how to use the VCR, right? and you had to help them with the VCR. I don't know how anything works today, so I'm turning into my parents. But it is something that we have to pay attention to. If you're a solo practitioner, you need to have some things in place. If you're part of a firm, you luckily have the benefit, I think, of a lot of security measures that you can take advantage of. But it's understanding what the other people you're working with are doing so that there's not that unauthorized access to confidential information being shared about clients.
I'll tell you that before the Panama Papers, before the Paradise Papers, the Latin American clients that we serve, and that's the majority, have always viewed the United States as a more secure environment for their information. And over those years, I mean, I've become, honestly, and I'm sure Jennifer too, the keeper of all family secrets, all corporate documents, all trust documents, the location of all bank accounts, all children, all paramours.
I was just about to say.
That because they haven't really trusted their home country jurisdictions, and maybe not their professionals, but just in general the security in their home countries. Information generally flows north; it doesn't flow south. I don't add more to what I get. I work with what I receive, and I deliver back what they know, unless I'm told to give them more. So that continues, and then this sort of disclosures of Panama Papers and Paradise Papers, whether those were legal or illegal or used by certain governments for any particular reason. Not only, like Jennifer says, in the tax context, but also in just the personal threat context. So we're all very sensitive to this. I think my own technological skills are pretty high, actually. Believe it or not, I'm the guy that calls when the IT goes home at night, and I'm there at 9 o'clock at night. Besides that, we continue to be protective of clients' affairs, and we have to continue to be diligent.
Right. For those in this area that practice, they're probably much more sensitive. But again, those that are new to this area need to understand these threats do exist and make sure they take some steps to protect the client. So that's it.
Okay.
So we're going to take a 10-minute break, and so we should be back here about 11:15, 16, okay?